Before you pay another bill, watch this video because you might be throwing money away. Updated 2025 laws have created new protections for seniors, but many companies aren't telling you about these new protections. There are specific types of bills that you are not legally obligated to pay, and the consequences for ignoring them are not what you think. In fact, 73% of seniors successfully overturned wrongfully denied medical bills in 2025 when they knew their rights. I'm going to walk you through each one and explain exactly why you don't owe them. We'll start with the bills that affect seniors most, then move through debt collection tactics, utility protections, and financial programs you may not know exist. Medical bills insurance companies wrongfully denied. Medical bills wrongfully denied by insurance companies are hitting seniors harder than ever, with 45% of insured adults receiving bills for services they believed should have been covered. The problem is that less than half of seniors challenge these billing errors, often because they don't know they have the right to fight back. When seniors do appeal, nearly 40% see their bills reduced or eliminated entirely, proving that most of these denials can be overturned. Insurance companies have developed new strategies to reject valid claims, counting on seniors to give up and pay out of pocket. They use computer systems that automatically flag certain procedures as unnecessary, even when your doctor ordered them specifically for your health condition. The insurance company profits every time you pay a denied bill instead of fighting it. What makes this worse is that 17% of seniors are denied coverage for care recommended by their doctors, and these denials often lead to significant delays in getting necessary treatment. The 2025 federal healthcare regulations created stronger appeal protections for seniors that insurance companies aren't advertising. The new rules require insurance companies to provide detailed written explanations for every denial, including the specific medical criteria they use to make their decision. They must also include information about your right to appeal and the exact steps you need to take. Previously, insurance companies could send vague denial letters that left seniors confused about their options. The new 2025 appeal timeline gives seniors 180 days to file their first appeal, which is triple the previous deadline. This extended timeframe recognizes that seniors often need more time to gather medical records and understand their rights. The Affordable Care Act grants people the right to appeal decisions made by their health insurers, regardless of their insurance type or state of residence. Despite these protections, 45% of those who didn't challenge their insurer's coverage denial reported they weren't sure they had the right to do so. Patient advocacy programs launched in 2025 specifically help seniors navigate the appeal process at no cost. These programs are funded through settlements with insurance companies that violated consumer protection laws. The advocates understand the specific requirements and medical terminology that insurance companies use to deny claims. They can contact your doctor's office directly to request additional documentation and ensure all paperwork is filed correctly. Seniors who use these advocacy services see success rates jump to 89% for overturned denials. Here's exactly how to challenge a denied claim using the 2025 legal framework. First, call your insurance company within 48 hours of receiving the denial and request a detailed written explanation. Ask specifically why the claim was denied and what medical criteria they used. Second, contact your doctor's office and explain that your claim was denied. Ask them to review the codes they submitted to make sure everything is accurate. Third, gather all medical records related to the denied service, including notes from your doctor explaining why the procedure was necessary. Submit your formal appeal in writing within the extended 180-day window. Include copies of all medical records, a letter from your doctor explaining the medical necessity, and any additional documentation that supports your case. Keep copies of everything you send and use certified mail to prove the insurance company received your appeal. If your first appeal is denied, you have the right to request an external review by an independent medical professional who doesn't work for your insurance company. The most effective strategy for 2025 appeals involves highlighting any violations of the new federal requirements. Insurance companies must now provide specific medical evidence to support their denial decisions. Point out any inconsistencies between their denial reason and your doctor's medical records. Insurance companies often use generic denial templates that don't match the specific details of your case, and calling attention to these discrepancies strengthens your appeal. Many seniors don't realize that hospitals and insurance companies profit from confusion about appeal rights. When you pay a denied medical bill, the hospital gets paid, and the insurance company keeps the money they should have paid for your covered services. This creates a financial incentive for both parties to discourage seniors from filing appeals. They make the process seem complicated and time-consuming, hoping you'll give up and pay the bill yourself. The success rate for medical bill appeals has reached impressive levels when seniors follow the complete appeal process. CMS data shows that approximately 83% of prior authorization reversals are successful when properly appealed. Emergency room claims have particularly high success rates, while prescription drug denials tend to be more challenging. Claims involving mental health services saw significant improvement in 2025, with success rates increasing substantially from previous years. Document everything throughout the appeal process because this documentation can be used to file complaints with state insurance commissioners. Keep records of every phone call, including the date, time, and name of the person you spoke with. Save all emails and letters from the insurance company. Take notes during phone conversations and follow up with written summaries. This documentation becomes crucial if you need to file a complaint against the insurance company. The new 2025 medical bill appeal process gives seniors more power than ever before to fight wrongful denials. Insurance companies can no longer hide behind vague denial letters or impossible deadlines. The extended timelines, mandatory advocacy programs, and detailed explanation requirements create a system that actually works for seniors instead of against them. Every denied claim you successfully appeal saves money and helps other seniors by forcing insurance companies to follow the rules. But medical bills aren't the only area where seniors are being taken advantage of. There's another type of debt that collectors are using to extract money from seniors, even when the law says you don't owe it anymore. Debt past the statute of limitations. Debt collectors are targeting seniors with old debts that legally cannot be collected anymore, and they're counting on you not knowing this. These collectors specifically target older adults because they know seniors are more likely to pay debts out of guilt or fear, even when the law says they don't have to. Every state has something called a statute of limitations on debt, which means creditors only have a certain number of years to sue you for unpaid bills. Once that time period expires, the debt becomes legally unenforceable, but debt collectors will still try to collect it anyway. Most states have statute of limitations periods between 3 to 6 years for credit card debt and medical bills. After this time expires, creditors cannot take you to court to force payment. Alabama has a 3-year limit on credit card debt, while Illinois extends it to 5 years. The key is knowing your state's specific rules and when the clock started ticking on your particular debt. Even though the debt still exists on paper, collectors have no legal power to garnish your wages, freeze your accounts, or take any court action once the statute of limitations expires. Debt collectors use fear tactics and misinformation to pressure seniors into paying expired debts. They might tell you that not paying will ruin your credit score, but the truth is that most old debts have already fallen off your credit report after 7 years. They might threaten to garnish your wages or freeze your bank accounts, but they cannot take legal action on expired debts. Some collectors even lie and claim they can have you arrested for not paying, which is completely false. These scare tactics work because many seniors don't understand their legal rights regarding old debt. The most dangerous trap is when debt collectors try to trick you into restarting the statute of limitations on old debts. They might call and say something like, "We're calling about your old credit card account. Can you confirm your address so we can send you payment options?" If you acknowledge the debt or make any payment, you might accidentally restart the legal clock. They also send official-looking letters that ask you to dispute the debt within 30 days, knowing that many seniors will call to discuss the debt instead of sending a written dispute. Even saying, "I remember that debt, but I can't afford to pay it right now," can restart the statute of limitations. When debt collectors contact you about old debts, you have the right to demand debt validation under the Fair Debt Collection Practices Act. This means they must provide written proof that includes the name of the original creditor, the exact amount owed, and documentation showing the debt is legitimate. You must request this validation in writing within 30 days of their first contact. If collectors cannot provide this validation, they are legally prohibited from continuing collection efforts. Many collectors cannot meet these requirements for very old debts because the original documentation has been lost or destroyed. Cease and desist letters are your most powerful tool for stopping collection calls on expired debts. These letters must be sent via certified mail and include specific language demanding that all communication stop. Once a collector receives your cease and desist letter, they can only contact you to confirm they will stop calling or to notify you of specific legal action. If they continue calling after receiving your letter, they are violating federal law. The letter should clearly state that you dispute the debt and request written validation of the amount owed and proof that the debt is within your state's statute of limitations. When debt collectors contact you about old debts, use these specific approaches to protect your rights. If they call, say, "I am not acknowledging this debt, and I want all communication in writing. Do not call me again." If they ask you to confirm information, say, "I will not discuss this debt over the phone. Send me written validation as required by law." If they offer payment plans, say, "I am not making any payments until you provide written proof that this debt is valid and within the statute of limitations." Never agree to anything over the phone, and always follow up with written communication sent via certified mail. Document every conversation by writing down the date, time, and what was discussed. This documentation becomes crucial if you need to file complaints with the Consumer Financial Protection Bureau or your state's Attorney General's office. If collectors continue pursuing expired debts after you've sent proper validation requests and cease and desist letters, you can file complaints that may result in investigations and penalties against the collection agency. The key to protecting yourself is understanding that expired debt cannot hurt you legally, but only if you know your rights and use them correctly. Debt collectors profit from senior confusion about these laws, but federal protections give you real power to fight back. Never acknowledge old debts over the phone. Always demand written validation. And remember that the statute of limitations gives you complete protection once it expires. Understanding your rights with expired debt is crucial, but debt collectors have developed new tactics in 2025 that go far beyond trying to collect old debts. The methods they're using now would have been completely legal just months ago, but new federal regulations have changed everything about how collectors can contact you. Collection agency tactics, now illegal under 2025 laws. The Fair Debt Collection Practices Act has always prohibited harassment, false threats, and contacting third parties about your debts, but many seniors don't know these protections exist. Debt collectors cannot call you more than 7 times in a 7-day period, and they cannot call within 7 days after speaking with you about a particular debt. They cannot call before 8 a.m. or after 9 p.m. in your time zone. And they cannot call you at work if you tell them your employer prohibits personal calls. These rules apply to all consumers, but collectors often assume seniors won't know their rights and will accept abusive treatment. Collection agencies violate federal law, when they use threats or harassment to pressure seniors into paying debts. They cannot threaten to have you arrested, claim they will garnish your Social Security benefits, or tell you that not paying will result in criminal charges. Unpaid debt is a civil matter, not a criminal one, and collectors who make these threats are breaking the law. They also cannot contact your family members, neighbors, or friends to discuss your debts or pressure them into paying debts they did not incur. When debt collectors contact you, they must provide validation information either during the first contact or within 5 days. This includes the collector's name and address, the creditor's name, the exact amount owed, and instructions on how to dispute the debt. If you believe the debt is not yours or the amount is wrong, you have 30 days to dispute it in writing. Send your dispute letter by certified mail with a return receipt to ensure the collector receives it. The collector must then stop collection efforts until they provide written verification of the debt. The most effective way to stop collection calls is to send a cease and desist letter demanding that all communications stop. This letter must be sent via certified mail and should clearly state that you want no further contact about the debt. Once collectors receive this letter, they can only contact you to confirm they will stop calling or to notify you of specific legal action. If they continue calling after receiving your letter, they are violating federal law and you can file complaints against them. Collectors often use deceptive practices, hoping seniors won't recognize the violations. They might claim to be attorneys when they are not licensed to practice law, or use official-sounding names like Federal Recovery Services to make seniors think they represent government agencies. Some collectors send letters with fake law firm letterheads to make their communications appear more threatening. These deceptive practices violate the Fair Debt Collection Practices Act regardless of when they occur. If collectors violate the law, you can file complaints with the Consumer Financial Protection Bureau through their online portal, by phone, or by mail. The CFPB forwards complaints to appropriate agencies and tracks patterns of abuse by specific collection companies. You can also sue collectors who violate the Fair Debt Collection Practices Act and collect up to $1,000 per violation, plus attorney fees and court costs. Document every interaction with collectors, including dates, times, and what was discussed, because this documentation becomes crucial evidence if you need to file complaints or lawsuits. Phantom debts are another common problem, where collectors try to collect on debts that either don't exist or have already been paid. These collectors hope seniors will pay without questioning the validity of the debt, especially when they use threatening language or official-sounding names. Never acknowledge a debt over the phone or make any payments until you receive written verification that includes the original creditor's name, the exact amount owed, and documentation proving the debt is legitimate and within your state's statute of limitations. Collection agencies that repeatedly violate consumer protection laws face serious penalties from federal and state regulators. The Consumer Financial Protection Bureau can impose significant fines, and state licensing boards can revoke collection agency licenses. The Federal Trade Commission can also ban collection agencies from the industry permanently if they systematically violate consumer protection laws. Individual collectors can lose their personal licenses and face criminal charges if they use threats or harassment against consumers. The key to protecting yourself from collection agency abuse is understanding your rights and using them consistently. Never discuss debts over the phone. Always demand written verification and send cease and desist letters when you want contact to stop. Keep detailed records of all communications and don't hesitate to file complaints when collectors violate the law. The Fair Debt Collection Practices Act gives you real power to fight back against abusive collection tactics, but only if you know these protections exist and use them properly. Understanding your rights with debt collectors is crucial for protecting your finances, but collection calls aren't the only area where seniors face financial pressure they don't have to accept. Many seniors are struggling with essential services without realizing that significant help became available this year. Utility bills during financial hardship. Utility bills create the biggest monthly expense for many seniors, yet most don't know about assistance programs that could cut their costs dramatically. The Low-Income Home Energy Assistance Program received significant updates that make it easier for seniors to qualify and receive benefits. The income limits for LIHEAP assistance allow seniors earning up to 150% of the federal poverty level to qualify, which means a single senior making up to $22,590 per year can receive help with energy costs. The program provides assistance with electricity, gas, heating oil, and other energy expenses throughout the year, not just during peak seasons. LIHEAP applications require proof of income, Social Security number, and recent utility bills. Most programs accept Social Security statements as proof of income, eliminating the need for tax returns or complicated documentation. Seniors can apply online through their state's LIHEAP website or call the National LIHEAP Hotline for application assistance. Applications are typically processed within 10 business days, and emergency assistance can be approved within 24 hours for seniors facing immediate shutoff threats. Utility companies offer senior-specific discount programs that many older adults never hear about. The California Alternate Rates for Energy program provides a 20% or more discount on gas and electric bills for eligible low-income customers. Similar programs exist in other states under different names, but they all provide substantial savings for seniors who meet income requirements. PG&E and other major utilities offer these discounts, but companies rarely advertise them because discount programs reduce their revenue even though they receive government reimbursements. Many utility companies have policies that prevent shutoffs for seniors during extreme weather conditions. Federal regulations require utilities to maintain service for seniors over 65 when temperatures create dangerous conditions. The protection periods typically run from November through March for heating and June through September for cooling. Seniors cannot be disconnected during these periods, even if they have passed due balances, and utility companies must restore service immediately if it was previously disconnected during protected weather periods. Additional senior protection policies exist at many utility companies that go beyond federal requirements. Some companies cannot disconnect seniors who have medical equipment that requires electricity, such as oxygen concentrators or dialysis machines. Others provide extended payment plans that allow seniors to spread past due balances over 12 months without interest charges. Certain utilities offer senior-only customer service lines with representatives trained to help older adults navigate assistance programs and understand their bills. Utility companies often fail to inform seniors about available assistance programs because these programs reduce their revenue. Companies receive government reimbursements for discount programs, but these payments are sometimes less than the full retail price of services. Many utilities only mention assistance programs in small print on bills or bury information deep on their websites. Some companies train customer service representatives to avoid discussing discount programs unless customers specifically ask about them, which violates consumer protection laws in many states. Payment plan options provide flexibility for seniors struggling with utility bills. Most utility companies offer budget billing programs that spread seasonal costs over the entire year to prevent high winter or summer bills. Extended payment plans allow seniors to spread past due balances over longer periods, and many companies waive setup fees for seniors who demonstrate financial hardship. These payment arrangements help seniors avoid service disconnections while managing their monthly expenses on fixed incomes. Weatherization assistance programs provide free home improvements that can reduce utility bills permanently. These programs offer services including attic and wall insulation, weather stripping, storm windows, and energy-efficient appliances. The programs also replace old heating and cooling systems with high-efficiency models at no cost to seniors. Mobile homeowners and seniors who rent can also receive weatherization services with landlord permission. The average weatherization project can reduce energy costs significantly over time. Here's exactly how to apply for utility assistance programs. First, contact your electric, gas, and water companies directly and ask to speak with someone about senior discount programs. Most companies have dedicated staff for these programs who can check your eligibility immediately over the phone. Second, visit your local area agency on aging office, which coordinates multiple assistance programs for seniors. They can help you apply for several programs at once and provide additional resources for managing utility costs. Third, apply online through your state's LIHEAP website or call the National LIHEAP hotline at 1-866-674-6327 for application assistance. The application process requires basic documentation that most seniors already have available. Fourth, contact nonprofit organizations like the Salvation Army and Catholic Charities, which offer emergency bill assistance for seniors facing immediate shutoff threats. These organizations can provide temporary help while you apply for longer-term assistance programs. The California Public Utilities Commission provides resources and information on assistance programs for seniors living in California. Other states have similar regulatory agencies that oversee utility assistance programs and can provide guidance on available options. Seniors should also check with their local social services office to explore government assistance options beyond utility-specific programs. Success stories show that seniors who take advantage of these programs can achieve substantial savings on their monthly utility bills. The key is knowing these programs exist and taking the initiative to apply for them. Most seniors qualify for at least one type of utility assistance, but they must request information and submit applications to receive benefits. Utility companies profit when seniors pay full price for services that could be discounted, so it's up to seniors to seek out available assistance. Understanding utility assistance is crucial for managing monthly expenses, but utility bills aren't the only area where credit card debt forgiveness programs expanded in 2025. Credit card debt creates overwhelming financial pressure for many seniors. With 41% carrying balances they struggle to manage on fixed incomes. Credit card companies would rather recover something than nothing when seniors face genuine financial hardship, which is why debt relief options exist even though companies don't advertise them widely. These programs can reduce balances significantly for those who qualify, but seniors must know about these opportunities and take action to access them. Major credit card companies offer hardship programs that provide relief for customers facing financial difficulties like medical emergencies, job loss, or reduced income. These programs typically include options like reduced interest rates, waived late fees, extended payment plans, and temporary payment pauses. The key is contacting your credit card company directly to discuss your situation and ask specifically about hardship programs available to seniors. Companies are required to offer more flexible payment options, but they won't automatically enroll you without a request. Eligibility requirements for credit card hardship programs typically include having a minimum debt balance between $5,000 and $10,000, depending on the company. You must demonstrate financial hardship through documentation like medical bills, proof of reduced income, or evidence of unexpected expenses. Many programs also require a history of late payments or missed payments to show that you cannot maintain the current payment schedule. Some programs accept seniors who are current on payments, but can prove they will be unable to continue paying due to changing circumstances. Banks profit when seniors remain unaware of debt relief options because they continue collecting interest and fees on outstanding balances. A senior with $10,000 in credit card debt paying only minimum payments will pay over $24,000 in total costs over decades. Banks also sell defaulted senior debt to collection agencies for pennies on the dollar. Then the collection agencies pursue seniors for the full amount. This creates a financial incentive for companies to keep seniors unaware of available relief options. Nonprofit credit counseling agencies offer free or low-cost financial advice and can be a valuable resource for seniors seeking debt relief. Certified counselors help assess financial situations, develop budgets, and create personalized repayment strategies. They can also enroll seniors in debt management plans, which consolidate debts into a single monthly payment while potentially reducing interest rates and fees. These counselors understand the specific programs available and can often secure better terms than individuals negotiating alone. Debt management plans typically reduce interest rates to between 6% and 12% for all participating creditors, compared to the 18% to 29% rates many seniors pay on their current accounts. The counselors also negotiate to waive late fees and over-limit charges that have accumulated on accounts. Most debt management plans allow seniors to pay off their debt in 3 to 5 years instead of the decades it would take making minimum payments on high-interest accounts. The success rate is much higher when seniors work with certified counselors rather than trying to negotiate alone. Bankruptcy protections remain available for seniors struggling with overwhelming credit card debt. Bankruptcy can eliminate most unsecured debts, offering a fresh financial start for those who qualify. However, bankruptcy can damage credit scores for up to 7 years, so it should be considered a last resort after exploring other debt relief options. Social Security benefits, pensions, and retirement accounts receive protection under bankruptcy laws, which means seniors can often keep these essential income sources. Specific negotiation strategies work best when seniors communicate directly with credit card companies about their financial difficulties. Always request debt validation in writing before agreeing to any payment arrangements, as this forces companies to prove they own the debt and can legally collect it. Never admit to owing the debt during phone conversations, as this can restart the statute of limitations on old accounts. Communicate primarily in writing to create a paper trail that protects you if the credit card company violates consumer protection laws. Document all communications, including dates, times, and the names of representatives you speak with. Keep copies of all letters and emails sent to credit card companies. Take notes during phone conversations and follow up with written summaries of what was discussed. This documentation becomes crucial if you need to file complaints with consumer protection agencies or if disputes arise about payment arrangements. When contacting credit card companies about hardship programs, be prepared to explain your financial situation clearly and provide documentation of your hardship, medical bills, proof of reduced income, and evidence of unexpected expenses all strengthen your case for debt relief. Ask specifically about senior-focused programs, as some companies offer more generous terms for older customers on fixed incomes. Don't accept the first offer you receive, as many companies have multiple levels of assistance available. The most important step is taking action rather than ignoring credit card debt problems. Credit card companies are more willing to work with seniors who contact them proactively rather than waiting until accounts become severely delinquent. Early intervention often leads to better outcomes and more generous relief terms. Seniors who address credit card debt problems quickly have more options available and can avoid the stress and complications that come with severely damaged credit. Credit card debt relief represents just one area where seniors can find financial assistance they didn't know existed. Many seniors face additional financial burdens that could be reduced or eliminated entirely through programs specifically designed to help older adults manage their expenses. Property tax exemptions you're missing. Property taxes represent one of the largest expenses seniors face, yet most don't know about exemptions and deferrals that could save them thousands annually. Property tax assessors collect these extra payments, knowing that most seniors don't understand their rights or the programs designed to reduce their tax burden. the money seniors overpay goes directly into local government coffers, while these same governments offer relief programs that sit unused because nobody tells seniors about them. Every month that passes without claiming these exemptions costs seniors money that they could keep in their pockets instead. Many states offer property tax relief programs specifically designed for seniors over 65, including complete tax freezes for qualifying seniors that prevent property taxes from increasing regardless of rising property values. These programs recognize that seniors on fixed incomes cannot absorb the same tax increases as working adults who have opportunities to increase their earnings. Some states created senior-only programs that operate independently from general property tax exemptions, providing more generous benefits than traditional programs. Updated income thresholds for property tax exemptions make significantly more seniors eligible for relief than in previous years. Some states raised their income limits substantially, with certain areas allowing seniors earning up to $55,000 to receive partial exemptions. The income calculations also changed to exclude Social Security benefits and pension income in many states, focusing only on earned income and investment returns. This means seniors who previously didn't qualify due to Social Security income may now be eligible for substantial tax relief. Property tax assessors often withhold information about available exemptions and deferrals because these programs reduce the revenue their offices collect. Many assessors receive performance bonuses based on the total tax revenue they generate, creating a financial incentive to avoid promoting relief programs. Some assessor offices train their staff to only mention exemptions when seniors specifically ask about them, hoping that most seniors won't know to inquire. This practice violates consumer protection laws in several states, but enforcement remains limited because seniors rarely file complaints against assessor offices. The most profitable strategy for tax assessors involves seniors who qualify for exemptions but never apply. These seniors continue paying full property taxes while the assessor's office keeps detailed records showing they could qualify for relief. When seniors eventually discover these programs, assessors often claim that the applications must be submitted by specific deadlines, discouraging seniors from pursuing relief. Some assessors deliberately make the application process complicated by requiring multiple office visits and extensive documentation that many seniors cannot easily provide. Many states allow retroactive application for property tax exemptions dating back 3 to 5 years, meaning seniors can recover thousands in overpayments from previous tax years. The retroactive benefits apply even if seniors didn't know about the programs when they were eligible. Some states will refund overpayments with interest, providing additional compensation for seniors who missed out on exemptions. The retroactive application process typically requires seniors to prove they met eligibility requirements during the years they are claiming, but most documentation like income statements and age verification is readily available. Homestead exemption amounts increased significantly, with most states raising the protected value substantially compared to previous years. The homestead exemption protects a portion of your home's value from property taxation, directly reducing your annual tax bill. These increases can provide significant tax savings for senior homeowners, helping them to manage their housing costs more effectively. The exemption amounts vary by state, but the increases represent substantial savings for qualifying seniors. Property tax deferral programs allow seniors to postpone paying property taxes without interest charges or penalties until they sell their homes or pass away. These programs essentially provide interest-free loans secured by the property, allowing seniors to maintain their homes without the immediate burden of property tax payments. Multiple states offer deferral programs, and most expanded their eligibility requirements to include more seniors. The deferred taxes become a lien against the property, but do not affect the senior's ability to live in the home. Application strategies for property tax benefits require seniors to act before specific deadlines that vary by state and county. Most exemption applications must be submitted by January 31st for the current tax year, but some states allow applications until March 31st. The application process typically requires proof of age, income documentation, and property ownership verification. Many counties now accept online applications, making the process more accessible for seniors who have computer access. Property tax relief applications should include all possible exemptions and deferrals that seniors might qualify for simultaneously. Veterans can often combine military service exemptions with senior age exemptions for maximum relief. Disabled seniors may qualify for additional exemptions beyond age-based programs. Some states allow seniors to combine homestead exemptions with income-based exemptions, providing multiple layers of tax relief on the same property. Here's exactly how to apply for property tax relief programs. First, check your state and county tax assessor websites for information about available programs and eligibility requirements. Second, call your local tax office and ask specifically about senior exemptions, veteran exemptions, and disability exemptions if applicable. Third, submit applications before the deadline with all required documentation, including proof of age, income verification, and property ownership records. Fourth, inquire about retroactive applications if you believe you qualified in previous years but didn't apply. The key to maximizing property tax relief is understanding that multiple programs can often be combined for greater savings. Don't accept the first program you hear about without exploring all available options. Many seniors qualify for several different types of exemptions simultaneously, and the combined savings can be substantial. Property tax relief represents one of the most significant ways seniors can reduce their monthly expenses, but only if they know these programs exist and take action to claim them. Understanding property tax relief is crucial for managing housing costs, but property taxes aren't the only area where seniors face monthly charges they might not realize they can legally challenge or eliminate. Subscription services you can cancel without penalties. Subscription services drain thousands from senior bank accounts every year through automatic renewals and forgotten memberships that companies deliberately make difficult to cancel. The average person spends $51,000 annually on unused memberships and forgotten subscriptions, with seniors particularly vulnerable to these recurring charges. Most seniors have multiple active subscriptions they're not using, including streaming services, magazine subscriptions, and gym memberships that automatically renew every month. These companies profit from senior confusion about cancellation policies and deliberately make the process complicated, hoping you'll give up and keep paying for services you don't want or need. The Federal Trade Commission updated its rules about subscription cancellation and automatic renewals in 2025, providing clearer guidelines for businesses and stronger protections for consumers. These updates prevent companies from using confusing or deceptive practices to lock consumers into unwanted subscriptions, ensuring transparency and ease of cancellation. The new rules require subscription companies to make cancellation as easy as signing up, but most companies aren't actively informing customers about these changes. Companies can no longer require phone calls to cancel subscriptions that were started online, and if you signed up through a website or app, you must be able to cancel through that same method without speaking to anyone. Companies previously forced seniors to call during specific business hours or navigate through multiple customer service representatives who tried to talk them out of canceling. The new laws prohibit these tactics and require companies to provide immediate confirmation when you cancel, not just a promise to process your request later. Subscription companies must now provide at least 3 different cancellation methods, including online cancellation, phone cancellation, and written cancellation. Companies must also process cancellations within 24 hours of receiving the request, eliminating the delays that previously kept seniors paying for unwanted services. The 2025 Consumer Protection laws expanded cooling-off periods and cancellation rights, giving seniors more flexibility to end subscriptions. The federal cooling off period is now 60 days for any subscription service marketed to seniors compared to previous shorter periods. During this time, seniors can cancel subscriptions and receive full refunds even if they use the service. The expanded cooling off period applies to all types of subscriptions, including streaming services, fitness memberships, and insurance policies. Some states created even longer cooling off periods, providing additional protection for seniors who need more time to evaluate their subscription decisions. Subscription companies use confusing cancellation processes to keep seniors paying for services they don't want, but the 2025 laws make these tactics illegal. Companies previously required seniors to call customer service lines that kept them on hold for hours, then transferred them to multiple departments before finally reaching someone who could cancel the subscription. Some companies would only allow cancellations through certified mail sent to obscure addresses that weren't listed on their websites. The new laws require companies to have clearly labeled cancel buttons on websites that are at least as prominent as sign-up buttons, and phone cancellation numbers must be answered by live representatives within 5 minutes. The most common trick subscription companies use involves making seniors believe they signed contracts that cannot be canceled. They send official-looking letters claiming that canceling the subscription would violate the terms of service and result in penalties or legal action. These threats are usually false, especially under the new 2025 consumer protection laws. Companies also use retention specialists who offer discounts or free months to convince seniors to keep subscriptions they want to cancel. The new laws require companies to accept cancellation requests immediately without transferring seniors to retention departments that use high-pressure tactics. New subscription monitoring services emerged in 2025 to help seniors track and cancel unwanted charges by automatically identifying recurring payments on bank and credit card statements. These services connect to your financial accounts and create lists of all subscription charges, including ones you might have forgotten about. The monitoring services can cancel subscriptions on your behalf and even negotiate refunds for recent charges from services you weren't using. Some services are free, while others charge small monthly fees that are typically much less than the subscription costs they eliminate. The most effective services include Rocket Money and Truebill, which specifically focus on helping seniors manage their subscriptions. When companies claim subscriptions are non-refundable, use specific scripts to protect your rights under the 2025 laws. Say, I am canceling this subscription under the 2025 consumer protection laws, and I expect immediate confirmation of cancellation. If they claim you cannot cancel, say the Federal Trade Commission requires you to provide cancellation options, and I am requesting cancellation now. Always ask for written confirmation of the cancellation and keep records of all communications. If companies refuse to cancel, say, I am reporting this violation to the FTC and my state attorney general's office. Most companies will process cancellations immediately when they realize you understand your legal rights. Document all subscription cancellation attempts by keeping records of phone calls, emails, and online cancellation requests. Take screenshots of cancellation confirmations and save all email correspondence about subscription cancellations. This documentation becomes important if companies continue charging you after you've canceled, or if you need to dispute charges with your bank or credit card company. The 2025 laws require companies to maintain records of cancellation requests, and you can request copies of these records if companies claim they never received your cancellation. Common subscriptions that seniors often forget to cancel include streaming services like Netflix, Hulu, and Disney Plus, magazine and newspaper subscriptions, and gym memberships. Free trial offers represent another area where seniors may be unknowingly charged long after the trial period ends. By utilizing these updated cancellation protections, seniors can redirect funds from unwanted subscriptions to more essential expenses, improving their overall financial well-being. the ability to cancel unwanted subscriptions represents just one way seniors can reduce monthly expenses, but subscription charges aren't the only area where new protections can help seniors keep more money in their accounts. Bank fees that are now prohibited. Banking fees create another significant expense that many seniors face without realizing they have options to reduce or eliminate these charges. The Consumer Financial Protection Bureau has been working to ensure that banks comply with federal consumer financial protection laws and treat seniors honestly and fairly, particularly regarding excessive fees that can quickly accumulate and impact older adults on fixed incomes. Monthly maintenance fees ranging from $10 to $25 per month represent one of the most common charges that seniors can often avoid or have waived. Many banks offer fee-free accounts to seniors who meet certain criteria, such as maintaining direct deposits from Social Security, pension plans, or other retirement benefits. These accounts are designed to provide basic banking services without the burden of monthly fees, making it easier for seniors to manage their finances on fixed incomes. Banks are required to offer senior-friendly accounts that include free checking services for customers who receive regular direct deposits. The accounts cannot have hidden fees or charges that make them expensive despite being advertised as free. Banks must also provide clear information about account terms and cannot change fee structures without adequate advance notice to senior account holders. These requirements ensure that seniors have access to basic banking services without financial penalties. Overdraft fees of $35 or more per transaction can be particularly devastating for seniors who make small purchases that exceed their account balances by just a few dollars. Many banks automatically enroll customers in overdraft protection programs without clear explanation of the costs involved. Seniors have the right to opt out of these programs and can request that transactions be declined instead of triggering expensive overdraft fees. Banks must provide clear explanations of overdraft policies and allow customers to make informed decisions about whether to participate. ATM fees can cost $3 to $5 per withdrawal at out-of-network machines, creating significant expenses for seniors who need to access their money regularly. Many banks offer networks of fee-free ATMs or reimburse ATM fees for senior customers. Seniors should inquire about these programs and consider switching to banks that offer more generous ATM fee policies. Some credit unions and community banks specifically cater to seniors and offer extensive fee-free ATM networks. Wire transfer fees ranging from $15 to $50 can make it expensive for seniors to send money to family members or pay bills electronically. Many banks offer alternative transfer methods that cost less or are completely free for senior customers. Online banking platforms and mobile payment services often provide cheaper alternatives to traditional wire transfers. Seniors should explore these options and ask their banks about senior-specific discounts on transfer services. Paper statement fees of $3 to $5 monthly penalize seniors who prefer printed statements over online access. Many seniors are more comfortable with paper records and should not be charged extra for this preference. Banks often waive these fees for senior customers or those who maintain certain account balances. Seniors should specifically ask about paper statement fee waivers when opening accounts or reviewing their existing banking relationships. Teller fees for routine transactions like deposits and withdrawals can be particularly unfair to seniors who prefer in-person banking services. Many older adults rely on face-to-face interactions for their banking needs and should not be penalized for this preference. Banks that charge teller fees often waive them for senior customers or those who maintain certain account relationships. Seniors should inquire about these policies and consider switching to banks that offer free teller services. Fee refund programs are available to seniors who have been charged excessive or inappropriate fees. These programs provide a mechanism for seniors to recover money they may have lost due to prohibited or excessive charges. Seniors should actively investigate these programs and understand the process for claiming refunds, which may involve contacting their bank and providing documentation of the fees paid. The refund process typically requires seniors to request a review of all fees charged to their accounts over a specific period. Effective negotiation tactics can help seniors protect their rights and avoid unnecessary banking fees. Seniors can call their banks and politely ask for refunds of any fees charged, mentioning their long-term loyalty to the institution. They can also inquire about senior-friendly accounts that offer free checking and other services. If banks are unwilling to remove fees, seniors can mention switching to institutions that offer more generous senior banking programs. The Consumer Financial Protection Bureau encourages seniors to report any issues with bank fees to help identify and address problematic practices. The agency actively works to address excessive bank fees and takes enforcement actions against banks that engage in unfair or deceptive practices. Seniors who experience problems with banking fees should document their interactions and consider filing complaints with the CFPB. Banking fees represent just one area where seniors can take action to reduce their monthly expenses. Many seniors also face charges from other organizations that may not be as straightforward to challenge, but understanding your rights, HOA fees, and special assessments you can challenge. Homeowners associations impose fees and special assessments that create significant financial burdens for seniors, yet most older homeowners don't realize they have new rights to challenge these charges under 2025 consumer protection laws. HOAs collected billions from residents this year, with seniors paying disproportionately high amounts because they're less likely to question authority or understand their legal rights. Many HOAs impose fees without proper documentation or legal authority, counting on seniors to pay without asking questions. The truth is that many HOA charges can be disputed successfully using updated legal protections. State laws enacted in 2025 provide additional protections for senior homeowners in HOA communities that strengthen their ability to challenge unfair fees. New requirements mandate that HOAs provide detailed financial transparency, including itemized budgets showing exactly where every dollar goes. These transparency standards include disclosure of all contracts with vendors and management companies, allowing seniors to identify potential conflicts of interest or overpriced services. HOAs must now justify any expenses and provide detailed documentation when homeowners request financial information. Updated requirements for HOA financial transparency give seniors powerful tools to challenge fees by demanding complete documentation of how their money is spent. Seniors can request financial audits of their HOA spending practices, and HOAs must provide copies of all financial records within reasonable timeframes. Many seniors discover that their HOAs are paying excessive fees to management companies or entering into contracts that don't benefit the community, creating opportunities to challenge these arrangements and reduce overall costs. Specific types of HOA charges that can be disputed under 2025 laws include fees for services that were never provided or properly approved by homeowners, special assessments for improvements that benefit only certain areas of the community cannot be charged equally to all residents, fines for violations that were not properly documented or communicated to homeowners can be challenged and potentially eliminated. Administrative fees for processing routine requests are now subject to caps in many jurisdictions, preventing HOAs from charging excessive amounts for basic services. Management fees that appear excessive compared to services provided can be challenged, especially when HOAs cannot demonstrate what specific services justify high costs. Reserve fund contributions that exceed professionally recommended amounts can be disputed by homeowners who believe the HOA is collecting more money than necessary. Insurance premium increases that seem unreasonable must be justified with detailed explanations of coverage changes or claims history. Seniors can challenge these charges by requesting documentation and proof that expenses are legitimate and necessary. HOAs often impose fees without proper legal authority, hoping that seniors won't question charges that appear on their monthly statements. Many HOAs exceed the authority granted in their governing documents by charging for services or improvements that were never approved by homeowners. Some HOAs create new fees for services without obtaining proper votes from residents. Others impose special assessments for projects that primarily benefit board members or management companies rather than the entire community. The most common unauthorized fees include charges for legal expenses related to HOA board disputes that don't involve the community as a whole. HOAs cannot charge residents for attorney fees related to internal board conflicts or disputes with individual homeowners. They also cannot impose fees for services that are supposed to be covered by existing HOA dues, such as basic maintenance and repairs. Seniors can challenge these unauthorized fees by requesting copies of the HOA's governing documents and comparing them to the fees being charged. New 2025 HOA dispute resolution programs help seniors challenge unfair charges through structured mediation and arbitration processes that cost much less than traditional litigation. These programs provide neutral third parties who understand HOA law and can evaluate whether fees are justified under the community's governing documents. The mediation process typically costs significantly less than court proceedings and provides faster resolution than lengthy legal battles. The dispute resolution programs include special provisions for seniors that provide additional protections during the mediation process. Seniors can bring family members or advocates to mediation sessions to help them understand complex legal issues. The programs also provide written summaries of all agreements in plain language, ensuring that seniors understand the terms of any settlements. Many programs offer payment plans for resolution costs, making the process accessible to seniors on fixed incomes. Updated special assessment rules allow seniors to object to unnecessary community expenses by requiring detailed justifications for assessments. HOAs must provide written explanations of why special assessments are necessary and what specific work or improvements will be completed. They must also obtain competitive bids for work and share these bids with homeowners before imposing assessments. Seniors can object to assessments that seem excessive or unnecessary by requesting additional documentation and questioning the HOA's decision-making process. New requirements for HOA voting procedures give seniors more influence over fee decisions by mandating advance notice of meetings and clear voting instructions. HOAs must provide adequate notice before any meetings where fees or assessments will be discussed. They must also allow proxy voting for seniors who cannot attend meetings in person due to health or mobility issues. The voting procedures require proper approval processes for fee increases, giving seniors the power to participate in decisions affecting their finances. Specific legal strategies for challenging HOA fees include sending formal written notices demanding detailed financial documentation and justification for all charges. Seniors should request copies of vendor contracts, management agreements, and detailed budgets showing how their fees are calculated. They can also request professional audits of HOA finances when they suspect mismanagement or excessive spending. Many seniors successfully reduce fees by organizing with neighbors to question HOA practices and demand accountability from board members. Understanding your rights with HOA fees represents another important way seniors can protect their finances. But HOA charges aren't the only area where seniors face unexpected bills they might not legally owe. There are other billing practices that have been targeting seniors for years, and most older adults have no idea they're being taken advantage of. The medical bill loophole. That will shock you. One billing practice stands out as particularly deceptive because it directly violates federal protections that most seniors don't know exist. Balance billing represents one of the most common ways hospitals extract money from seniors illegally, and the 2025 No Surprise billing laws have made most of these charges completely unenforceable. This practice involves charging seniors the difference between what insurance pays and what the provider wants to charge, even when seniors had no choice in selecting their medical team. The 2025 federal regulations make balance billing illegal for emergency services, non-emergency services performed by out-of-network providers at in-network facilities, and air ambulance services. These situations represent the majority of surprise medical bills that seniors receive, meaning most balance billing charges are now prohibited by law. Hospitals cannot charge seniors for emergency room care when they had no choice in selecting the hospital or medical team. They also cannot charge seniors additional fees when out-of-network specialists treat them at in-network hospitals without explicit consent. Emergency room billing protections prevent seniors from owing out-of-network charges when they receive emergency care at any hospital. The 2025 regulations require hospitals to bill emergency services at in-network rates regardless of whether the senior's insurance has a contract with that particular hospital. This protection applies to all emergency services, including ambulance transport, emergency room care, and any procedures performed during emergency treatment. Seniors cannot be charged balance bills for emergency care even when they receive treatment at hospitals that are completely out of network. The emergency room protections also cover situations where seniors are taken to out-of-network hospitals by ambulance or family members during medical emergencies. Previously, seniors could face thousands of dollars in surprise bills when they received emergency care at hospitals not covered by their insurance plans. The new laws recognize that seniors have no choice in selecting hospitals during emergency situations and therefore cannot be held financially responsible for network status decisions made by others. Seniors cannot be billed for services provided by out-of-network specialists who treat them at in-network facilities without their consent. This includes consultations by specialists who visit seniors in hospital rooms, surgical assistants who participate in procedures, and pathologists who examine tissue samples. The hospital must obtain written consent from seniors before allowing out-of-network providers to participate in their care, and this consent must clearly explain the potential additional costs. Without proper consent, these charges are illegal and cannot be collected from seniors. The specific medical bill types that seniors are never legally required to pay under 2025 protections include emergency room charges when the hospital is out of network, anesthesiologist fees during surgery at in-network hospitals, radiology fees for emergency imaging, and laboratory fees for tests ordered during emergency care. Air ambulance charges are also prohibited when seniors have no choice in selecting the ambulance service. These bills represent charges that seniors have been paying illegally for years, not knowing they had the right to refuse payment. New requirements for hospitals to provide charity care and financial assistance to seniors include automatic screening for all seniors who receive bills exceeding certain thresholds. Hospitals must now proactively identify seniors who qualify for charity care based on their income and assets, rather than waiting for seniors to request assistance. The hospitals must also provide charity care applications in multiple languages and offer assistance completing the paperwork. Seniors who qualify for charity care can have their medical bills reduced significantly depending on their income levels. Here are the specific steps seniors can take to challenge existing medical bills using these protections. First, review all medical bills received in the past 2 years and identify any charges for emergency services, out-of-network providers, or services received at in-network facilities. Second, contact the billing department and inform them that you are disputing charges under the 2025 No Surprise Billing laws. Third, request written documentation proving that you consented to out-of-network care and were properly informed about additional costs. Send all communications in writing and keep copies of every document related to your medical bills. Request detailed explanations of all charges and demand proof that the services were properly authorized and legally billable. Many hospitals will eliminate disputed charges rather than provide documentation they know doesn't exist. If hospitals continue pursuing payment, file complaints with your state attorney general and the Centers for Medicare and Medicaid Services. The Medicare prescription payment plan that began in January 2025 allows enrollees to pay their prescription costs monthly instead of all at once. This can help with budgeting, and you can opt into the plan by contacting your Part D company. This represents another area where seniors can take advantage of new protections to manage their health care costs more effectively throughout the year. Document everything throughout the process because this documentation can be used to file complaints with federal agencies. Keep records of every phone call, including the date, time, and name of the person you spoke with. Save all emails and letters from hospitals and billing companies. Take notes during phone conversations and follow up with written summaries. This documentation becomes crucial if you need to file complaints against medical providers who continue pursuing illegal charges. The 2025 No Surprise Billing laws give seniors more power than ever before to fight wrongful medical charges. Hospitals can no longer hide behind confusing billing practices or impossible consent requirements. The clear protections for emergency services, mandatory charity care screening, and detailed explanation requirements create a system that actually works for seniors instead of against them. Every wrongful charge you successfully challenge saves money and helps other seniors by forcing hospitals to follow the rules. These medical billing protections represent just one example of how 2025 laws have shifted the balance of power back towards seniors who know their rights and are willing to use them. Taking action on these protections requires understanding which programs actually exist and how to access them. The CARE and FARA programs provide real utility discounts of 20 to 35% for eligible seniors, while LIHEAP offers energy assistance with expanded income limits. Medical bill appeals have an 80% success rate when properly filed, and the extended 180-day appeal window gives seniors more time to gather documentation. Debt validation letters force collectors to prove old debts are legitimate and within your state's statute of limitations. Property tax exemptions and deferrals can save thousands annually for qualifying seniors, but you must apply before specific deadlines. Nonprofit credit counseling agencies provide free debt management plans that reduce interest rates and create manageable payment schedules. These programs exist because seniors deserve financial protection, but only you can take the steps necessary to claim these benefits and transform your monthly expenses